one.
Yes, this is Ingrid Calvin. This is my sample of an attorney-client contingent fee retainer agreement. And the undersigned Valerie victim requests the legal services of attorney and barrister for representation to assert a claim for damages against Professor Tortfeasor arising out of an occurrence on or about an incident in which client was assaulted. Number one, the conditions basically means the agreement will not take effect until it's fully signed and dated with a retainer, if any. The scope of services basically says we will represent you to the fullest until a settlement or judgment is reached. We may consult with other attorneys and services, and it will not increase or affect client's obligation to pay attorney fees as included in the agreement. The client duties basically means you must be truthful, keep us informed, and pay the bills on time. You agree to appear for all meetings and hearings. Failure to comply may result in the attorney canceling this agreement without notice. Next is the deposit. In this case, the deposit is $0, but we do reserve the right to demand further deposits as we deem needed or prior to or after actual expended costs. If requested, you agree to pay all deposits or advances within 10 days. Any unused and unearned deposits at the end of our services will be refunded. Number 5, legal fees, costs, and billing practices. We will only be compensated for attorney fees related to legal services rendered. The attorney fees to be paid to us will be a percentage of the gross recovery. The percentage is 30%. The gross recovery basically means the total of all amounts received. Number 6, cost, litigation, expert fees, and expenses. Means that while it's a professional attorney, we may advance certain costs on your behalf. On your demand, you agree to pay for all actual estimated costs, disbursements, expenses. You may be required to make a deposit for cost before the expenditure is made by the attorney. Number 7, billing statements. We will send you billing statements for all costs, disbursements, and expenses. If an outstanding bill statement is not paid, interest will occur, normally 10%. The unpaid balance will bear interest until paid. Number 8, approval necessary for settlement. We will not make any settlement or compromise of any nature of any claim without your prior approval. But if you go on your own and try to make a settlement without your attorney, you also grant us a legal and equitable attorney lien. Number 9, limitation of representation. Means that such a discharge or withdrawal does not, however, relieve you of the obligation to pay any fees or costs. If you decide to, no, I'm sorry, limitation of representation. We are representing you only on a matter described herein. It just says it for itself. But discharge and withdrawal, number 10. If you decide to withdraw or discharge us as your attorney, you still are responsible for fees and costs, even after the fact. Number 11, disclaimer of guarantee. We make no promises or guarantee how much you will recover, or if you will win the case, we can't guarantee the outcome of the matter. Number 12, attorney's authority. You give us full power to execute all pleadings, documents, claims, deposits, checks, releases, etc. If the attorney is unable to locate you, the attorney will have to resolve your case however he sees fit in the best interest of you. Number 13, mediation and arbitration agreement regarding disputes. Basically, it's saying you are waiving your rights to submit any dispute or any cause of action you may have against us to a jury. That means that you are agreeing to arbitration as set forth above. You are giving up your rights to an 8 jury trial as the claims covered. That means you have no problem with the fees. So you're refusing to go to trial if you decide that you're not happy with the fees and costs. Number 14, attorney fees clause. Without this clause, if you were to win your case, you could end up paying your own attorney fees and costs if this clause was not inside the agreement, included in the agreement. Number 15, the entire agreement. That means the agreement contains the entire agreement of both parties. 16, independent attorney review. You have the right to have to get a second opinion, to have an attorney to review this before you sign it. Number 17, effective date. The attorney and client relationship will commence on the date of this agreement, not before. And then below, the parties, after you have read and understood the terms, if you agree with them, the attorney will sign, and all parties involved will sign, print and sign your name and date it. And that's the end of my sample contingent and retainer fee form. Thank you.